South Africa's constitution, to many a beacon of hope, marking the transition from apartheid to democracy. To others, a template that's past its prime. This debate is more than just an academic exercise. It's a mirror reflecting on our nation's journey, the obstacles we've encountered, and the future we're striving towards. Good evening and welcome to Unfiltered. I'm Sizwe Mpofu Walsh. Is South Africa's constitution the ideal blueprint for a complex society? Or does it fall short in addressing our nation's challenges? Here to offer their insights on this important issue, I'm very excited to be joined by Charmika Samaradi Vakera Vijay Sundara, Senior Lecturer at WITS, and Professor Pierre De Vos, a constitutional law expert from UCT. Before we begin our discussion, here's a short insert that provides context of the conversation that we're having tonight on some of the critical perspectives that have emerged on the Constitution.
The best constitution for who? Based on whose reality, based on who's experienced, based on whose idea of what a good society, a just society, a fair society is to look like. My own view of the South African constitution is that it's not the best constitution of the world for a vast majority of Africans, South Africans who are still reeling from nearly 300 to 400 years of colonial oppression and apartheid violence. And I think we need to have a different conversation about the kind of society that we live in. The question is not whether this is the best or worst constitution in the world, even though I think that the language of best constitution in the world silences, papers over a lot of the contradictions and inequalities that our society continues to face. It's a celebratory narrative that is now out of sync with the sentiment of a large part of our society, which sees these social contradictions, particularly social contradictions around race, around land, but also around inequality, gender-based violence, and so on and so forth. So I have doubts about whether it's the best constitution. I even have doubts about whether it's our constitution. I even have doubts about whether it's the right constitution for our society.
Welcome back to Unfiltered. Professor De Vos and henceforth Pierre, if I may, thank you very much for joining us. And how do you respond to Professor Mudiri's remarks there? Of course, I think it is also fair to say that's probably the minority position. The Constitution enjoys a wide range of public support. It's a document that's invoked by many politicians across the spectrum. But of course, there is perhaps a growing critical voice on the Constitution. What are your thoughts on that initial intervention?
Well, I think Professor Modiri has a point when he says the celebratory nature in which we engage with the Constitution can be problematic because for two reasons. Firstly, if you use the constitutional discourse and rights as we in South Africa do, almost so many of our political disputes about economic injustice end up in the courts, and that tends to depoliticize these disputes. And it also, if you frame everything in terms of the Constitution, and on paper it is a very, I disagree with Professor Modiri, it is actually a remarkably progressive and good constitution. But if you frame everything in that way, and if you depoliticize these discussions, what happens is it becomes more difficult to talk about the actual injustice in our society, or what Professor Modiri calls the contradictions, and it makes it difficult, or it legitimizes in a way the current situation, which is unconscionable. You can't really. It's difficult to justify that. So I would say that what is the problem is we should be a little bit more careful to say that because the Constitution as a text is good, that means South Africa is actually a society that is relatively successful or just or whatever the case might be.
It's really interesting to hear your perspective there, Prof. And Charmika, if I may as well. What's your response to both Prof. Modiri and Professor De Vos's view on, in some ways, just the way the Constitution is invoked and the massive celebration of the document, and how, in some ways, that obscures the document, but also where our society is at this point.
Absolutely. Thank you, Sizwe. I think as a starting point, it's always interesting to me to separate kind of the rhetorical claims of the Constitution and the purposes that they're supposedly attached to, right? So I think, for me, the starting point always when thinking about the utility of the Constitution, whether it's worth celebrating, is asking the question of what it's meant to achieve and whether we can say it's achieving that. And I think from that perspective, there are elements of both what Pierre and Joel have said that I would agree with. But I think it's very important, as Prof. Joel Modiri has mentioned, to think about this not as an isolated question of the here and now, but read it in its historical context. And as Pierre has said, to read it in its political context. And for me, that starting point, that question of, is the Constitution designed to constitute, and if so, what? And the claims towards justice that sometimes get kind of intermingled with claims towards its ability to achieve kind of socioeconomic rights, its claim to achieve kind of the alleviation of poverty and inequality. Those are very distinct claims. And if we unpack their relationship to politics, their relationship to economics, their relationship to society, and how those concepts are kind of mingled and intermeshed in ways that we can't neatly separate, then I do think we have to think very carefully about not only whether it's accurate to simply celebrate and mythologize the Constitution as the harbinger of justice, but recognize the ways in which that can be damaging to a project of actual intervention on the needed interventions to truly address and alleviate poverty and inequality, not in isolation, but as symptoms of a deeper question of injustice, an unresolved question of injustice.
Pierre, of course, feel free to respond to anything that comes out of what Chamika says, but I think one useful place to also start would be to think of the kind of vision for our society that the Constitution espouses, especially in its early sections, so in the preamble, in the founding provisions, and to some extent in the Bill of Rights. And there is this view emerging that those sections maybe don't go far enough. I think they go far, but the question is, do they go far enough? What's your thought on whether the founding aspects of the Constitution, which really sets the vision trajectory for the document, is appropriate for our society right now?
Well, of course, the preamble, for example, speaks about egalitarian society, non-racial society, diversity, all of those things, and the argument that says it doesn't go far enough would complain or would point out that the Constitution was part of the negotiating process, that it didn't constitute a radical break with the past, with colonialism and apartheid past, and that it is a compromise. So the interest of different groups, both the colonizer and people who have been colonized, there had to be some kind of accommodation of those. So, sure. And that is reflected in some way in those earlier provisions. But I would say that the problem, in a way, is a problem that I think I was very much guilty of when the Constitution was first adopted, is to think that this document, no matter what words you put in it, that could actually radically change the society or could facilitate the change. I think it's important to understand that constitutions are there to organize how a country is governed, to regulate and check exercise of power. The Constitution does that marginally relatively well, and the way it is interpreted by courts, because also the document is not a dead document, it is something that is interpreted by courts and change over time. But the operationalization of it, so to speak, is it depends on people with power in society. It depends on the politicians. It depends on people who wield economic power, and that is and there is a huge gap between what these promises say. In egalitarian society, for example, there is no egalitarian society in South Africa, and there hasn't been the people who wield power, not only politicians, but also other people who really wield power, have not really, by and large, taken up this challenge and really tried to even begin to address this fundamental founding injustice which the Constitution found, so to speak, when it was adopted.
Indeed, we're in a fascinating conversation this evening about South Africa's Constitution. It's a document that's been lauded for being one of the most progressive constitutions in the world, for taking South Africa to a new era of rights. Others have criticized it for not going far enough, or perhaps needing a revamp. When we come back from the break, we're going to look at some of the questions about how does the Constitution cause events in society, and how far can it go? Is it the Constitution or the government to blame? And is our state designed optimally? Stick with us. Welcome back to Unfiltered. One of the key debates in our society at the moment is the Constitution fit for purpose? Of course, many people laud the Constitution as the document that has extricated us from our apartheid past and set us on a democratic trajectory. Some question whether the Constitution needs to be reviewed, re-looked at. Some even say rewritten, and it's that debate that we engage on this evening. Charmika, could I come to you? Professor De Vos Pierre raises an interesting point about the causal impact of a constitution. It's one thing to put words down on a text, and it's another for that to have impact in a society, and that requires the government, that requires the whole society. Are critics of the Constitution unfair in blaming the Constitution for where we are, and what causal role do you think it's playing in our society right now?
Thank you, Sizwe. So I think the starting point is that I'm not sure that I'm hearing critics blaming the Constitution per se, simply being critical of it and questioning the possibilities of it actually achieving any social justice or justice broadly related ends, and particularly whether it is purpose-made, in the words of Sanele Sibanda, or Dr. Sanele Sibanda, to actually intervene in systemic poverty and inequality. And I think a useful way to think about it, as Pierre has mentioned, this wasn't actually always, in the last 10 years even, accepted that the Constitution isn't just this fundamentally wonderful value-based document, but is a product of compromise. And therefore, paradoxes and contradictions are inevitable. But not only, I think, should we be questioning, or do critics, I think, call for us to be questioning whether it's capable of achieving justice, but question the ways in which it is a barrier to achieving justice. And I think questions around, is it really our Constitution? What kind of society does it constitute? What are the implications politically, in a political economic sense, for the kind of social, economic, structural arrangements that are envisaged in the Constitution, either overtly or covertly, or rather indirectly. The recognition of private property, that's received a lot of attention, but the question of the kind of private property regime and the kind of economic regime as more than a kind of neutral, empirical function of markets, but as fundamentally something that's empowered by public authority, and in this case, constitutional public authority. So then the short answer, I think, is I don't think it's unfair to blame the Constitution, but I do think it's absolutely fundamental that we start to question without rejecting the premise that law is absolutely neutral, or that even value systems, where they sound good in the abstract, I don't think anyone's arguing against equality, dignity, or freedom. But the question is, what does it mean more than something that we utter into structural relations, given South Africa's history of brutal colonial apartheid, racialized, gendered, kind of structural disparities?
Pierre, just on this question of the causal nature of the Constitution, I put it to Charmika that maybe there's too much emphasis on how much the Constitution is playing a causal role. That's one criticism of that position. But those who defend the Constitution often seem to appreciate it has a causal role for the good stuff. So they say that, it's created, it's, for one thing, it's helped us to have a universal franchise, for example. So it clearly does have a causal role sometimes. But when things go wrong, they say, well, you can't blame the Constitution for that. It's the government. So this causal role and exactly what the Constitution in our society is doing, I think, is quite an interesting question that seems to be right at the center of where we are right now as a country.
Yeah. Yes, so this is, I think, quite a complicated question, because the problem of South Africa fundamentally is one that there are systemic and structural injustice that needs proactive, rather radical action to undo. So the first question then would be, if you think about the Constitution, is does the text and the way it is interpreted by the Constitutional Court and other judges, does it prevent such radical action? And if so, how? Are there any examples in the case law? Maybe it does, the text does, or the way it is interpreted by the judges. Maybe that be, if that is so, we should say that we should appoint better, more radical judges, or we should change the text. But I haven't seen much evidence that the text and how it is interpreted has actually torpedoed actual steps being taken to make such radical changes. In fact, during President Zuma's the presidency, he appointed an independent panel or group of experts to look at this, and they found that the courts actually have been marginally a source for good in trying to effect social economic change. But the courts, the judges, individual cases that go to the court, that is not going to radically change anything. So I think if we expect the Constitution and its enforcement itself to do the work, so to speak, of dismantling the structural injustice, that is not going to happen. If we are going to claim that it does, then I think that would be wrong. But maybe there's a difference between that and arguing that because we have the text, because of how it is interpreted, it is impossible for society, for the government, for anybody with power to do more because that's not, I don't think that is true. The problem fundamentally, or one of the problems, is that there is a widespread consensus about the economic models, capitalism, all of these things. I don't read the Constitution as requiring one specific economic system, and maybe we can argue about that, but there has not really been a fundamental challenge to the basic assumptions of how societies are supposed to be organized, how the country is to be governed, what the economic system is supposed to be. And that is a conversation that is maybe made more difficult because of the celebratory way in which you talk about the Constitution, but I don't think the text of the Constitution and how it is interpreted very necessarily make it impossible to think of different ways of going about addressing the injustices in our society.
Tramika, how do you respond to that, and especially the suggestion that there haven't been many examples of the Constitution itself being an impediment to overcoming the structural injustices of which you've spoken?
I appreciate particularly the last line that Pierre mentions, that he doesn't interpret the Constitution as making it impossible. And I think it's useful to kind of linger there for a moment, because I think often the conversation gets to that. And as you mentioned in kind of just previously, that sometimes there's almost a double speak in the sense of what the Constitution's capable of versus what its limitations are, depending on the context. And I don't mean this as a slight, but just as a useful kind of, as something useful that's surfaced. Is it an exercise of interpretation, and should what we be striving for is kind of interpreting out of a framework? And if we find ourselves interpreting out of a framework, we need to ask ourselves, what is that framework? Is it the Constitution that's creating that framework? So the notion of kind of a capitalist society that is potentially inherently exploitative and private power. Does the Constitution, lauded for its ability to serve as a check on governmental power, including through constitutional supremacy. But what is the equivalent, and is there not call for equivalent of private power, especially given that the private-public distinction itself is in some ways fictional, not because there isn't legitimate public function and a reason to view these as categorically separate. Public functionaries, government, and the legitimacy through democratic election does make it a distinct kind of category of power we can accept. But what is private power, especially in a context like South Africa? If we think about even the notion of the corporation as a separate juristic person, so we're not simply dealing with collectives of individuals, but individuals that are theoretically put on par with every other individual, including those that have been had labor and land appropriated from them in the process of colonial apartheid. Right? So the question of then what may not seem overt as barriers and what may require interpretation is not operating as a text in isolation, but operating in this context of the compromise, of economic relations being skewed and still appearing to demonstrate quite kind of apartheid colonial logic. So what I say by this, again, there are ways in which this can be kind of invoked as a trope. But literally the notion that there are segments of society that are normalized to simply be in poverty, or normalized to have to employ or be employed in terms of wage labor, the terms of which may be tinkered with or negotiated. But the fundamental questions of at what point were people's subsistence, identities, entitlements to exist and make sense of what it means to exist in the world, violently dispossessed from them, and at what stage is the Constitution that comes in with view to supposedly achieving justice, perpetuate either a version that seeks and centers redistribution and justice in that sense, versus one that simply perpetuates dynamics where private interests can be insulated and protected. And there's much attention to Section 25, but something that is also worth noting is that we're dealing with a suite of kind of provisions and a suite of protections. Section 8.2 receives less attention. This is the ways in which basically juristic persons are recognized as persons for the purposes of the Constitution.
Right.
There is that, there's the positive aspect of the kind of vertical application of human rights, so the fact that human rights apply between people. And that could be seen positive interpretation-wise as a way to hold private interests liable. But the other side of this is the protection of private interests in the sense that they now enjoy rights in the Bill of Rights in the same way that individuals.
So I want to come to that because I think you've taken us to an interesting point in our conversation, which is to what extent does the Constitution help us to avoid the kind of economic injustices which are often premised on private relations of power. We'll come back to that question after the break. We're in a fascinating conversation, debate, discussion with two of the foremost thinkers on the Constitution in South Africa. Professor Pierre de Vos will be back after the break with Ms. Wijesundara as well. Stick with us. Welcome back to Unfiltered. The Constitution is lauded as one of the world's most progressive documents, and it marked our passage away from an apartheid past into a democratic era. But of course, there are critical voices questioning whether the Constitution is still the prime blueprint for our society, or whether we need to revisit some of its sections. Pierre, can we come on to this question of the domain of private power? Because in many ways, this is where power lies in South Africa. The government can, well, we've seen the government certainly failing, and I don't think anyone is here to defend the ANC government's record on service delivery, etc. But the question of the Constitution's ability to penetrate contractual relationships between private parties, even check the excesses of corporate power has started to come to the fore. What are your thoughts there on this is often called the horizontal application of the Constitution?
Yeah. So the text of the South African Constitution is quite interesting, and if you compare it to old-fashioned liberal constitutions, maybe even radical, in that it does, as Shamika said, say that it's not only the state that can interfere or infringe on rights. Private individuals, corporations, they can also, it's recognized that they can infringe on rights, and that power doesn't only lie with, it's not only public power that's a problem, it's private power as well. But firstly, our courts have not been very good at actually applying that. I mean, in the law of contract, there are quite a few very messy judgments in which the basic idea of freedom of contract is still being protected, although it's really a fiction. There's very seldom a freedom of contract between two completely unequal parties. But also, maybe there's something else which I don't really know how to deal with, and I'm not sure any constitutional design can deal with this, is that power, constitutional and rights kind of action, if you will, assumes in a way that a right is infringed through a specific act. You do this and you take away my rights, while the way in which subjugation is perpetrated by private power is not necessarily through an identifiable individual act. Corporation X does this, and so people cannot fulfill their potential. It's a kind of slow violence that power is exercised in, it's difficult to explain, but it's exercised in almost invisible ways, and that is very difficult to arrest through legal action, because you have to take an individual case to the court, while what is really needed is to address some of the systemic problems that perpetuate the current system in some way or another. I hope that somebody clever enough will come up with ideas of how to do this through law. At the moment, I'm not sure it can be done through law and courts. It needs to be done through other processes, through political action, and these are political issues. If you go through the courts, also it depoliticizes what are fundamental political disputes in our society. So, I'm a bit ambivalent about the whole thing, because on paper it is there, but it's very difficult actually to address, and I agree with Shamika.
No, it's a really fascinating point, in fact, in terms of the way that rights are assumed to work, and it's actually just wonderful to hear these different perspectives, because I think this debate is often so polarized that we don't have these more nuanced debates that are really about exactly what's going wrong and how it can be fixed and whether it can be fixed. Shamika, that's quite an interesting point about the limits of any constitution to affect private relations, and especially the way in which they work, which can sometimes be quite different to state-led injustices. What do you make of that point by Pierre?
So I appreciate the point of reflection that the point makes, because I feel like that's actually the nub of, in many ways, the tension. Yeah. Why is this not something that the law, this law that's committed to justice, equality, egalitarianism, why is it something that falls outside of the law, seemingly? Why is it a question of politics? Why is it a question of economics? And I think this is why critiques of the Constitution that attack essentially the paradigm are worth being attentive to. It's not a question of unquestioning adherence, but the merits of the underlying critique or argument. At what point does the law separate, or is the law instrumentalized to separate economic and political? And is that justifiable? So on the one hand, if you think about private parties as individual actors, you and I interpersonally interacting, it may make sense to separate the private from the public, although feminist theories, black feminist theories, critical theorists for centuries, or at least generations, have been arguing that that itself is worth questioning, whether even on an interpersonal level we can make that distinction. But it gets even more complicated when you realize, and it is now fairly commonly understood, that certain corporations have powers equivalent to states in terms of the powers that they wield. And while it is true that some of the operations of that power are not as simple as a direct act, although direct acts are also visible, what's equally true is the absence of the ability for the law seemingly to systematically intervene also hints at the way in which the law empowers the existence of the private actors, the kind of contractual and other kind of structures that exist that facilitate these transactions in the first place. So in other words, the law is not only sometimes in operation and other times not. It's just only sometimes visible and in other times not. And in the instances where it's not visible, it's not up for interrogation, and in instances where it's depoliticized, it no longer becomes, or essentially questions that should be in the realm of ultimately political or moral political decisions. How do we distribute resources? What are our priorities? Who should be allowed to exercise what power and what restraints should operate on that? Is not a one-sided and should not be a one-sided discussion in terms of public and private power. But it is a function of oftentimes liberal constitutions, and this is not even necessarily isolated to South Africa's experience of the Constitution. Even with progressive terminology or wording, it is a tendency of liberal constitutions to insulate private power and essentially economic issues from political contestation.
Pierre, maybe one interesting way to add a layer to this, because Chamika's very helpfully, put the reason why private power does matter for law, is to look at questions of property in the Constitution, of course, Section 25. And what's interesting there is 25.1 will effectively guarantee a right to property, and then the rest of the sections are about how that right, infringing on that right, as it were, can be permitted. And so we kind of frame it as the justice is an infringement on a right that's permissible, rather than maybe starting with people deserve a right to a just distribution of property, and then kind of framing the opposite, if you get my drift. So the framing of that is an interesting question for property, for the private domain, and the society as a whole.
Yes, obviously, well, not obviously, my take on the why it is was done like that is because it was because people with economic power, they insisted on this. It's in their interest, and so that's also why it would be very difficult to change. But I think the problem is maybe bigger than that, and that is that it also presupposes a very specific idea of property. What is property? It's something that you hold to the exclusion of everybody else. It's a very specific idea of property that is linked to very specific ways of people in living with each other, and our courts made in the early years of the Constitutional Court suggested that it's necessary for us to rethink what property really is, how it can possibly be regulated, and to move away from this idea that property is a private thing that you hold in opposition or to the exclusion of others. But that hasn't really been developed. So I think that is something fundamental that the courts, if they wanted to, or maybe if they were pushed more to do so, could help to rethink, because given the property distribution in South Africa, and given the way in which people who do have property use that power that it gives them, often to perpetuate or to protect themselves and their financial and other interests from others, there are some discussion to be had about how we can change that. Some people will say we should have expropriation without compensation. In theory, yes, we know that all the land reform programs that have been instituted have been not very successful, often mired in corruption, so there are practical issues there. So, yes, so I think there's a debate to be had how practically, given the political dynamics and other dynamics in South Africa, you're really going to make a difference and address the problem. It's open to debate, I think.
Indeed. We're in conversation with constitutional experts on South Africa's constitution, its merits and its demerits. There's been a debate in our society about whether the constitution is indeed the document that should be lauded internationally as a progressive move away from apartheid into democracy, into rights, or whether the Constitution has been an impediment to achieving some of the structural changes that are required for a just society. When we come back from the break, we'll discuss where to from here, what kind of changes could be implemented in South Africa's constitutional architecture, if those changes are even necessary at all. Stick with us. Welcome back to Unfiltered. We're discussing South Africa's constitution this evening. Chamika, can I ask you, and I'm going to ask Pierre the same thing, but in reverse, what do you think is good about the constitution?
I think viewing it as a compromise document, the fact that it is a centralized place in which to engage in essentially debate over what is the kind of society we wish to envisage, and the ability to build in basic protection that interest groups and their blocks of power at the time, as it were able to kind of essentially articulate. So understanding it as a compromise document and understanding the transition without the ease of the armchair critic that assumes that it was that easy, or that there weren't tensions or conflicts or potentially aspects to the picture that may not even be still fully visible to us now. I think as that starting point, I can appreciate that it's the product of activism, that it's the product of kind of, lobbying for better or for worse, before we kind of commit to or comment on the decisions made therein. I think the merits of kind of going the route of constitutionalism versus kind of liberation in a more radical form are an entirely different kind of discussion.
Sure.
So it's not to reduce that, but in response to that kind of direct question, I think as a compromise document and looking at the law as a site not only for oppression but as a site for resistance, but recognizing that it's a cop-out to stop there and see that as the be-all and end-all.
Pierre, Justice Albie Sachs, decorated and brilliant judge, was once asked if he thought the Constitution was perfect. And he said, well, I don't think the question is perfect. So there is a kind of there's a tendency to avoid even suggesting that anything could be changed. Do you think that, I mean, you literally edited the textbook on the Constitution. Is there anything you would criticize about it?
Yeah, there are. I think that the way in which the Constitution deals with the distribution of power between national government and provincial government is a complete mess. It's impossible to know what it means. Practically, provinces are really become glorified implementing agencies for the national government. So it's because it's this compromise. It's not a federal system. It's not a unitary system. It's somewhere in the middle. So that's really a problem. Something else that is really not written in the text, but is also fundamental for making the Constitution something that you can use to resist, is that most South Africans have no access to courts, to lawyers, cannot pay lawyers, cannot go to the court, cannot challenge either individual acts of injustice or abuse of power or whatever. You need either lots of money, whether you're funded by the state or not, or you need an NGO to help you to go to the court, which is one way of actually trying to use the Constitution to challenge power in various forms. And that is very difficult in South Africa. If it wasn't for NGOs and for the state funding various court cases of people getting into trouble, it would be difficult. Most people, many of the judgments that we do have would not have happened at all.
Can I stick with you on that, because it's an interesting point. A lot of the debate around the Constitution is about, and maybe I've fallen victim to this tonight, about the values and the Bill of Rights, and no one gets beyond Chapter 2, basically. But the actual Constitution is about how we design the country. And so many times, in conversations where you ask about service delivery or some crisis that's happening, it's because no one in government seems to know who has power over what. And I do think that question about the design of the state and the three-tiered system of local, provincial, and national, and who actually does, who actually delivers things, we probably need to have more of in addition to the debate about values and the underlying assumptions?
Yes. So the problem is, of course, that one can see that the design in this particular context, South African context, with specific political dynamics, might result in might have really bad results. I mean, local government on paper it's really is fundamental, but it doesn't always work. But if you change it, the constitutional design is not science. It is a bit of a hit and miss art form. The same rules or arrangements in one context, in one society, or at one level of government might work very well, and in another one not. If you change it, it might create new problems that you didn't foresee. The judgment of the Constitutional Court and the powers of the public protector, and that they are binding, for example, at the time, many people said this is a great judgment. And then you realize things change, and now, there's a person here with a lot of power that is really very difficult to check. And maybe making that change had all these bad and unforeseen consequences. So it's actually really difficult to know if you change something, whether it will actually fix the problem that you have now identified.
Shamika, of course, feel free to respond to anything Pierre has said, but I guess the remaining question is where to and what do we do from here? There's a view that the Constitution is perfect and everybody else is effectively to blame for where we are. I don't think anyone has taken that view tonight. There's a view that, you know what, it's imperfect, but it's decent and we should turn our attention elsewhere. There's also a view that we need to make serious reform to the Constitution, keep its good parts, reform some of its bad parts. And then there's a view that we need to start from scratch. What do you think is the appropriate course from here?
So personally, I think it's worth paying attention to the arguments made in all, and particularly the less kind of mainstreamed arguments of the last 2 points of kind of radical reform or doing away with it altogether. Recognizing that even within these calls, there are different kind of motivations, arguments being made. So I would kind of, as a starting point, urge people to engage with the actual substance instead of being reduced to kind of polarized debates. And I appreciate that you didn't kind of ever present it as that. But speaking to that then, I think it's important for us to recognize the Constitution as both an enabler and a disabler, potentially, but also operating in a broader context. And again, that not as just an abstraction, but that as something with very real implications. If it doesn't impact the economy, and why? What assumptions are we taking for granted in terms of what it means to live in human society? Individualistic kind of survival of the fittest, mitigated by some kind of, welfare kind of safety nets. Is that appropriate in any context, but especially in a context where, again, we're dealing with poverty and inequality that's quite very directly causally linked to colonialism and apartheid, right? And I think sometimes it's in sometimes trying to isolate the issue to one thing. It's if we fix the structure of government, everything will be fine. If we fix the property clause, everything will be fine. I think we can recognize that we have instruments at our disposal now that have their possibilities and limitations, but that approach must be critical, and it must be together with a longer-term approach, asking questions of the very paradigms we take for granted. From the critical school that calls for abolishment, that's sometimes caricatured in kind of more mainstream spaces, is the understanding that the underlying kind of ethical legal paradigm is different in, for example, African jurisprudence. Understanding Mulao, or the law, not as an equivalence, but as something that wouldn't recognize prescription, meaning that property unjustly obtained should ever have validly been recognized as having passed to the current obtainers that use that same property to exercise economic power in order to further oppress. So,
no, absolutely. Yeah. And can I ask you in terms of the practicalities of the Constitution, and I appreciate your point about the deeper underlying ethical assumptions, but is there anything that you think would actually make a difference if you were... And I mean, it's always unfair to say, how would you rewrite the Constitution? Because it was a product of like 1,000 different people coming together. But are there aspects of it that you believe could change for the better, and what would those be? Maybe one or two.
Right. So I think outside of a general consideration of the paradigm that it presents, which I do think, again, is not simply an abstract question. It's a question of distribution and what our priorities are. I would rethink the fissure between the public and the private, or the ease at which that's kind of crystallized in the document, and the supposedly unintended consequences, or at least elided consequences of this. What does it mean to give, for example, a corporation that's amassed property and wealth over centuries, including into apartheid, internationally and nationally, so transnational corporations as well, the rights to equality, privacy, etc.? You know, those have very real implications. And again, it's difficult to raise some of these critiques without undermining the kind of notion of constitutional, liberal constitutionalism anyway. One thing that I would like to also kind of reflect on is we decry the kind of access to courts. And I think that that's a legitimate point. If we think about that, again, in isolation, people should have access to courts. So it's not to say that NGOs don't do important work. But Zanele Sibanda, for example, has described transformational constitutionalism as kind of translating into kind of enlightened legal liberalism, where that is seen as the route to justice. It's atomized, it tends to be individualized. Even if it's public interest, it is in a particular kind of isolated space as opposed to kind of far-reaching. Tsepo Madlingozi too has kind of reflected on the ways in which NGOs in some ways perpetuate, as far as paradigm goes, the notion of the kind of savior-victim dynamic. And going back to the question of what is the problem and how do we frame it, what have we taken for granted in framing it, including the fact that people shouldn't be entitled, empowered in material, in symbolic, in kind of the ways in which they operate in the world, to not have to ask for someone else to be able to speak for them, to not have to be able to do that because they have the ability to sustain themselves or kind of subsist. And in what ways have structures and powers actively deprived people of that?
Right. Absolutely. Pierre, we only have a minute left, I'm afraid, but just to give you an opportunity to respond and say anything you'd like to in closing as well.
Yes. I think that it is important for me at least to think on two tracks. The sort of symbolic track and the problems that arise when you have a constitution that is a compromise, that doesn't recognize fundamentally that there needs to be a fundamental break, a radical break with the past, and on the other hand, thinking that there is power. People are going to exercise it in different ways. There needs to be some document, a constitution that is regulating that, and it's trying to do it in a way that is going to prevent the worst abuses. And that is whether our constitution does that. I think in the way that constitutions work, it probably does it as best as it can in the circumstances. But that still doesn't really solve the fundamental structural problems in South Africa, and I don't think any other constitution or changing the constitution is likely to do that. It needs to be a radical different kind of politics in South Africa and a different kind of imagination of how the world ought to be for that to happen.
Well, Pierre, thank you so much for sharing your insights and considerable wisdom on this. And Chamika, thank you so much for the same and for really bringing across the critical case in such eloquent ways. We appreciate you joining us. Tonight, the debate over the Constitution has become polarized. People on either side of the debate are called names. But we've tried to distill the debate down into a productive one about what do we need to preserve and the creativity to have the bravery to change where change needs to happen. Let's continue this conversation on social media at Unfiltered SABC. And thank you for joining us for another conversation, another Unfiltered News, Unfiltered Views, and Unfiltered Conversations. Have a good night.